Tuesday, but we had something we wanted to talk about. So we are here today to talk about House Bill 93. Larry, can you explain a little bit about what that is?
So House Bill 93 is a proposed legislation regarding the no-fault provision in divorces. I think in the 70s, Texas, among other states, passed a no-fault bill allowing couples to divorce without claiming fault on the other party.
Right.
So this bill here, the proposed legislation is to repeal the no-fault provision, leaving only certain items for the couples to divorce.
So before we talk about how that will affect actual divorces, let's talk about the items that you would have to prove if this bill passed to get divorced.
Yeah. So what would be left over in the Texas Family Code? We've got cruelty, we have adultery, we have conviction of a felony, we have abandonment, living apart, and then confinement in a mental hospital.
Okay, so living apart is 3 years.
Yes.
Then you have cruelty, which isn't just, you're an awful person talking to one another. Right. You have to show continual cruelty. Yeah, continuous things like physical attacks, consistent yelling and anger, even flaunting a new affair in front of your spouse. And adultery, you actually have to prove that there was an actual act. Yes, an actual act. A lot of times what you see in these cases is people will say, oh, there's adultery. And it's like, well, where's the proof? And the only thing they have is maybe text messages, or they see an email that alludes to something. But it's very rare that you see people who are like, here are pictures, here's this, here's that, like the full cheaters type of thing. Right. So in many courts, they look for that. They want to see that consensual sexual act that has occurred between a spouse and someone not the person's spouse. And so the text messages or emails will have to specifically say, when we did said act, something like that. Okay, so which is not common because people know not to put that in writing. Exactly, yes. Okay. So the next one is conviction of a felony, which is pretty simple to understand. Doesn't happen all the time. Yeah. And abandonment. And abandonment, yes. And there is a time period for that as well. Yes, at least a year they have to be away and have abandoned the marriage, abandoned everything about the spouse. Okay, so that doesn't mean they still call or visit their kids. That means they abandoned. They're totally like back in the 40s and 50s where they just took off and started a new life. Okay. So that's very, very rare. Yeah. All right. So let's talk about how that will affect divorces and what that actually looks like. Well, currently the way things are, everyone knows that when there's a divorce, emotions are high. Especially if you have children, emotions are extremely high because you've got mothers and fathers who do love their children and they're fighting over certain things. But a lot of times when you have a divorce that's filed and you have the no-fault provision that's in there, no one has to say you're at fault for destroying this marriage. They basically allow it to say, hey, look, we just don't agree. We kind of fell out of love. Let's work amicably throughout this process so that we can move on with our lives. With that gone, someone's going to have to say somebody's at fault. I think the least invasive out of all the options that would be left over is living apart. You have to live apart for at least 3 years. For couples who don't want to do that, someone's going to have to do a track record of every time this person was cruel. If they believe there was adultery, they're going to, maybe private investigators to find that information. So it's going to cause a lot of strife, I think, that now that family law attorneys, we look to try to help people settle things outside of court, to work together so they can move on. Now, it seems like we're going to do a lot of fighting if this gets passed. So this all has to be filed in a petition, right? Yes. Or a counter petition, which means you have to detail this stuff in a pleading, which is a record of the court, and then you can pull that record at any time. Yes. Throughout the rest of your life. Yes. So if you want to talk about, any physical altercation that happened and the times that happened, that's going to be on public record. So if you want to run for office later down the road and maybe when you were 19 things got out of hand, that's going to be in there.
That information's going to get out there, yes.
If you committed adultery and there were text messages, that information is going to be there forever. And so any future career or relationship aspirations could be tarnished by this record, right?
That information, yes. And there are several times where we have clients who come in and they say, hey, look, this is what has transpired throughout the marriage. And it's some pretty awful stuff.
Mm-hmm.
But they're like, look, I don't want that out there. I just want to be done. I want to just get it done and then move through. But that's because we have that no-fault provision in place. With that gone, that info is going to come out.
Right.
I mean, if the parties want to divorce, quickly, instead of waiting that 3 years, that info is going to come out. And, if one person's throwing dirt, the other one's going to throw dirt because they don't want that to be on the record. So it's just going to make things very contentious.
I will say that 90% of the time, people come in and they'll tell me all of these things and they'll say, but I don't want that out there. I have had 1 or 2 people who have said that, yes, I want that in the petition. I want them to know what they did to me. I want them to pay for what they did to me. And those are very, very rare and not always the best option. Generally there are kids involved in many marriages, and we try to protect the children as much as possible. And so explaining to them that putting this stuff in a court record allows them to go and see what happened to their parents later on down the road. And if you detail all of that stuff, it can really have a devastating effect in the future on the children. Not to mention what's happening at the actual time of the divorce.
Exactly.
And that doesn't count for just, small children, all children. Even adult children can be affected by the disputes of their parents. So if this were to pass, then the only options would be to put your business out there in the public and then fight about it.
Yeah, and that's the unfortunate part. And I was reading some background on who proposed the legislation and why they were doing it. And it talks about the sanctity of marriage, and I don't want to step my feet too much into that, but I think the idea behind it is, hey, we want to try to keep marriages together and make it to where people just can't say, hey, I just want to quit. That's understandable. But then at the same time, people are people. People grow apart. And if the driving force behind this proposal to repeal the no-fault is to try to keep marriages together, I think there may be a better way to do it.
Absolutely.
Like maybe propose counseling, before you file, or some co-parenting classes, something to basically focus on the cause of the issue, not the effect.
Right, you can't force people to stay together who don't want to be together.
Exactly.
It's just not going to happen.
Yes.
What is going to happen, and the reason in the 70s they decided to change the rule, is that people are going to be cruel to one another to try to get what they want.
Yes.
And, in relationships, somebody feels hurt, and so they're going to lash out. And that lashing out is going to destroy the whole family. Maybe counseling is the answer, or at least some pre-divorce counseling may be a better idea, just to see if there is any ability to save the marriage. But I don't think that forcing people to disclose private information is going to be helpful in the divorce proceedings. So there is a backup bill.
Yes, House Bill 65.
Okay, tell me about that.
So in case House Bill 93 fails, the backup is House Bill 65, which basically takes the time frame for 60 days before the court can grant a final decree of divorce. It takes it from 60 and increases it to 180 for couples who have children under the age of 18 or are still in high school.
Okay, so kind of forcing them to stay a little bit longer.
Yes.
Ultimately, most divorce cases with children last longer than 60 days. There's temporary orders hearings, and then there's this time period that people are allowed to kind of see if it works, see what works. And that lasts anywhere 3 to 4 months, and then we move forward with mediation after that. But this would take away options.
Yes.
There wouldn't be any option to try to work it out before filing divorce. And I think that's important to recognize, because people don't just jump up one day and say, I'm going to a divorce attorney.
Exactly.
They spend a lot of time trying to make it work and make it work. Sometimes we'll have people come in here multiple times saying, okay, I'm ready now. And then they wait. And then they come back, nope, he did it again, or she did it again. I'm ready now. And then they'll wait. And then they'll pay the retainer and they'll be like, hold off, don't do it just yet. And then they'll just sit there. The retainer will sit in a trust fund, and it'll just sit there until they decide they're ready. And that could be a year, 2 years, whatever they want to do. If they keep in contact and say, just wait, hold it, I'll be there. But if you force people to have a 6-month waiting period, then I think that there's going to be less of that, less of them trying to work it out on their own, because they're going to want to hurry up and get it on file.
Yes. So
that they can move on in a quicker time. But I don't know that that's going to be helpful either.
Yeah, I don't know. I don't know what to say with regards to both bills. Part of me, years ago, I would say there's no chance this would ever pass. Mm-hmm. I can't say that.
Things have changed.
Yeah, things have changed. So, it's something that we're definitely watching, because if it passes, it's going to change the entire landscape for not only couples who are potentially going to divorce, but family law attorneys as well. Because then now we have to change our strategy on how we do things. When you have some who are more focused on trying to get the parties to settle in sex that it can be an amicable split. Now we have to be pure fight mode, because we have to make sure we have everything on file to get what is best for our client. Well,
and House Bill 93, the one that requires a fault reason, I think the state is kind of overstepping a little bit into the personal lives of people. They're forcing regular average people with problems, people have problems, they just do, regular average people to disclose all of this information in a state recorded document. Yes. It's just a bit of an overreach, I think. For most people, it's private information. Private information should not be forced out there, and it doesn't really do any good. I absolutely believe that maybe counseling or some efforts to reconnect people are always a good idea. We almost always recommend co-parenting classes, right?
Yes, always.
It's vital that two people that are still parenting have at least some education on how to do that. But forcing the fight in court in a government entity is a little bit of an overreach. But we're going to keep an eye on it, and any changes that come up, we will let you know. We'll be the first to let you know. I think we're going to post a blog on our website today about all of this, and I guess we'll just wait and see.
We'll wait and see.
All right. If you have any questions, you can leave them in the comments, or you can give us a call at 817-841-9906. Also, we have a couple other videos that we did over the past couple weeks that weren't live, so feel free to just scroll down and check them out. And we will see you on Friday. Bye.